Hi, welcome back to Your Future, Your Finances. We're talking again with Jason Frank of Frank and Share regarding elder law and estate planning. Good tips here for a family who's taking care of a family member who perhaps has developed a need for nursing home or other medical circumstances. Welcome back to the show.
My pleasure.
We were talking about people who are elderly or need nursing home care, but what if there's a disability or there's a disabled person who needs help?
Well, we were talking about the 5-year look back on asset transfers and how it doesn't apply to spouses. Well, one of the other areas where it doesn't apply is if there's a disabled child or if there's any disabled person under age 65 in the family, because the person who's going into the nursing home was looking for public benefits, Medicaid to help pay the nursing home. There are particular federal rules that allow any of their funds to be given just outright to a disabled child, or trust for disabled child, or trust for any disabled person under age 65, which in my experience, I think with one exception, has always been a disabled grandchild. So, if you've got the 80-year-old mother with a 50-year-old disabled child who she's had with her all her life, and she's going into a nursing home and she's going to have to qualify for Medicaid, rather than leaving this 50-year-old disabled child alone and penniless, she can either transfer all her assets to him or a trust for him. She qualifies for Medicaid. He doesn't lose any of the benefits that he's receiving, and things can be better. Can't make her better, but at least the financial situation can be addressed.
How important is it that this planning is all done as proactively as possible?
Well, I wish I could tell you it should all be done, years in advance before you know anything. But honestly, the rules change constantly, and I would say 90+% of our business is crisis-driven. Right? No one ever believes it's going to happen to them.
Yeah.
So the tools that we strongly recommend. I mean, everybody needs a will. Everybody needs a medical advance directive. But people come in and say, what's the magic trust that solves all my problems? Well, there really isn't any. I mean, they all think they're going to say some sort of exotic trust. And I rarely find that that's true. What we find to be the most useful tool is a power of attorney that has certain provisions in it. One that allows gifting, another one that allows the creation of trusts, both for the person whose power of attorney it is, and for other family members who might need it, like a disabled child, and the ability to change beneficiary designations, because sometimes that can prove to be a disaster. So what we're looking to do for most people is a power of attorney, a statutory form power of attorney since the law changed in 2010, with certain additional provisions in it so that if something happens, we're in a position to do what we can do to maximize the ability to protect assets. It's a power of attorney. It's not some kind of crazy trust.
Yeah. Going back to Medicaid and the nursing homes for a second. So if you go on Medicaid, do you give them your house? Is that how it works?
No.
How does that work?
I mean, technically, if you're talking about a single person or a couple.
Either one.
Well, a couple of the house is protected for the well spouse, and you want to retitle it in the spouse's name and do all that kinds of stuff. But if you have a single person who's going into a nursing home and they have a house, and as long as the equity this year doesn't exceed $552,000, it's an exempt asset. In other words, they can qualify for Medicaid without selling the house. Now, the problem is, once they're on Medicaid, the state says that you can't use your income to maintain it, so you can't pay the taxes, the insurance, the utilities, or the maintenance, and the state will put a lien against it. So they don't take it. They just put a lien against it, and if it hasn't gone to tax sale by the time you die, then the state will sell it and pay themselves back. We rarely let that happen. The only times we usually get into something like that is if we have somebody who has a lot of high care needs and probably a relatively low life expectancy. Otherwise, we're going to probably sell it and do what we can do to protect some of the proceeds, which we can almost always do, especially when there's a power of attorney with a gift clause.
But the state then has a lien or a right to some portion of the house. How aggressive is the state when that scenario plays out?
Well, I mean, if they put a lien against the property, they're going to execute on it. Now, if there are grounds to have made an exempt transfer of the property to either a caregiving child, this is some of the other exemptions. If a child lives with a parent and takes care of them in the parent's house for 2 years, the house can be given to the caregiving child. And we've even had situations where we've gone back 10 years and proven that was the case. And the state's been willing to release their lien. We have a situation now where we're waiting for the results from a Social Security hearing as to whether or not one of the children was disabled at the time that mom died, in which case the state's agreed to release the lien if we can establish that. So I mean, there are always things you can do. I mean, nothing's ever over and done. That's why they're lawyers. That's what we do.
How about, do you have couples who are getting divorced for some sort of planning advantage for Medicaid or other purposes?
That comes up somewhat infrequently. Does come up. Second marriages where there are prenups, sure. Typically, second marriage where the other spouse is now out of state, yeah. Or certainly spousal refusal, which is another asset protection technique. Honestly, we have found very few people who've been married for 50 years who are willing to say, I'm going to get divorced.
Right.
It does happen, just not often. When they do come in and say that, it's because they've been aching to get divorced for the last 49.
Okay, all right. You mentioned a term earlier. It was a special needs trust. So what is that and when does it come into play?
Well, a special needs trust is a pot of money, a trust containing assets that sits sort of on the side and doesn't count in determining eligibility for public benefits. There are actually 7 different kinds of special needs trusts in Maryland. 4 of them are creations of federal law. And the real question that you got to deal with is whose money is it? All right? If it's the disabled person's money, there's 2 options. If it's somebody else's money that's being put into a trust for a disabled person, well, then there's like 5 other options. 2 of them are functions of federal law, and 3 of them are based on Maryland law, and each one of them has a different consequence. Each one of them has a good and a bad, a pro and a con, and you have to sit down and look at them as to which one's the best way to go. Adding to that, you now have ABLE accounts, which are the ability to set aside funds. It's sort of based on the 529. It's sort of based in tax law. And it lets you put $14,000
brand
away.
new. We'll have to have you back on to talk a little bit about that. Website and email address?
The website is frankelderlaw.com, www.frankelderlaw.com. Please feel free to email. You'll get something back from me. And my email address is jfrank@frankelderlaw.com.
Fantastic. All right. Lots to know. Definitely affects a lot of people. Thank you for watching. You're watching Your Future, Your Finances.